Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and I'm also the founder of the Arizona Consumer Law Group, where I help people in the state of Arizona who are dealing with serious debt problems file for bankruptcy, defend lawsuits, and all those other horrible things out there. Well, in today's video, I want to talk about Chapter 7 bankruptcy, and specifically, if you're considering a Chapter 7 bankruptcy, I want to give you 5 reasons why you may want to reconsider. Now, you may be thinking this is a little bit counterintuitive for a bankruptcy attorney to tell someone not to file for bankruptcy, but there are absolutely situations where you should not file a Chapter 7 bankruptcy if you fall into any of these categories that we're going to talk about today. The first one is if you have significant assets. Now, in Chapter 7 bankruptcy, most assets are protected. There are various exemptions, both on the federal level as well as here in Arizona, under Arizona state law, that can protect your assets as you're going through the bankruptcy process. It's important to understand when it comes to Chapter 7, the idea behind it is it eliminates most of your unsecured debt, like credit card debts, medical bills, personal loans. Those go away completely. However, on the flip side, the bankruptcy court is going to look to see, are there any assets that you own that could be sold for the benefit of your creditors? Now, like I said, there are all these exemption laws in the state of Arizona that do protect most assets. And because of that, most people that go through Chapter 7 don't lose anything. For example, there's the homestead exemption, protects up to $425,000 of equity in your home. That's as of 2025. Vehicles, you could have up to $15,000 of equity, one for each spouse in a married couple. Household goods, retirement accounts, all of those things are protected. But if you have assets above and beyond that, particularly assets that are owned free and clear, Chapter 7 may not be a good option for your situation. So, for example, let's say you had a rental property that was owned free and clear, or a rental property that had a loan against it, but there was some equity in it. You wouldn't be able to claim the Arizona homestead exemption there and protect it, so you would lose that asset in a Chapter 7. The bankruptcy court would sell it, take the money, and give them and distribute those funds to your creditors. Other examples, if you have ATVs, if you have a boat that's paid for or that has significant equity, or let's say you had multiple vehicles. As I mentioned, you're allowed an exemption in a vehicle with up to $15,000 of equity. And if you're married, you each get a vehicle with up to $15,000 of equity. Let's say you had 4 vehicles in your name. You can protect 2, but the other 2 may be not protected, and you could lose those through the Chapter 7 process. So if you have significant assets, or if you have assets that are not of the kind that are protected by one of Arizona's exemption laws, Chapter 7 may not be a good option. Now, the second reason that you may not want to consider Chapter 7 is because you don't qualify. Now, when a lot of people think of qualifying for bankruptcy, they start to think about the amount of debt that you owe. And surprising as this answer is, really the amount of debt is largely irrelevant in the Chapter 7 proceeding, and particularly in determining if you qualify for it. What we look to see if you qualify for a Chapter 7 is we look at the number of people who live in your household and the amount of income that you who are filing the bankruptcy, what's your income and the income of your spouse combined, how much that is in total. So, for example, I'm recording this in January of 2025. The cutoff for an individual in the state of Arizona is $66,340 per year, or approximately $5,528 per month. If you make at or less than that, you do qualify for a Chapter 7. However, if you make more than that, then you likely will not qualify for a Chapter 7 bankruptcy. Now, it is important to note, if you're close, there are various deductions that can be made, and you may still be able to qualify for a Chapter 7. But if you're an individual here in Arizona, again, the cutoff is about $66,000 a year. And these numbers change. That's why I gave you the date there. They do change as the years go on. They are adjusted. But let's say that you are an individual in Arizona. The cutoff is $66,000. If you're making $90,000 a year, you're likely not going to qualify for a Chapter 7. And you're going to have to look at other options like non-bankruptcy options or a Chapter 13 bankruptcy, which I'm going to discuss in other videos. Now, just to give you an idea, there is a sliding scale based on the number of people in your household. Again, in Arizona, in January of 2025, the cutoff is $66,340 annually. However, if you have 8 people in your household, the cutoff is $147,544. So about $13,000 a month. So you can see that there is quite a bit of movement as far as the number of people in your household and the amounts that you're able to make. It's also important to know that even if you're filing bankruptcy without your spouse's income is going to have to be included in the total amount in determining if you qualify for filing a Chapter 7. So the second reason that you may not want to file a Chapter 7 is because they won't let you, because you make too much money. The third area where Chapter 7 could be problematic is in the area of transferring of assets. Specifically what I'm talking about, if you have transferred an asset out of your name to somebody else and you didn't receive the fair market value for it in return. Now, this can be a problem, particularly amongst family members. If you transfer a vehicle, a house, something like that, where you transfer the asset out of your name and you're not getting anything for it, or you're getting relatively little for it. A common example I see at my law practice here in Arizona is parents will transfer a vehicle out of their name and into the name of their 18-year-old teenager who has been driving the vehicle. Unless the teenager gives you money in exchange for it, the fair market value, that can be problematic because you are transferring an asset out of your name without receiving anything in return. Under the bankruptcy code, if you were to file a Chapter 7 bankruptcy, the bankruptcy trustee who gets assigned to your case could then go back and recover that vehicle, bring it back in, and potentially sell it, and then distribute the money to your creditors. The workaround with something like that, if you're in a situation where you have transferred the asset, if you were to wait 12 months from the time that you made that transfer, then it likely would not be an issue. But that's definitely something to talk to a bankruptcy attorney about so that you can get an understanding of whether that's going to be an issue and make it so Chapter 7 is not a good option for your situation. Now, the fourth reason you may not want to consider a Chapter 7 bankruptcy is because of what are called preferential payments. Now, in bankruptcy, a preferential payment is when you make a payment to the benefit of your creditors that is more than they would have received if they would have been included in your bankruptcy. Now, these fall into two general categories. The one is just a general preference. And what this states is, under the bankruptcy code, if you pay back a creditor more than what they would have received in the Chapter 7 process within the 90 days prior to filing bankruptcy, the bankruptcy court can go and recover those funds and distribute them evenly amongst all of your creditors. Now, this type of preference is generally not a big deal because, for example, let's say you paid your American Express card a bunch of money in the 90 days prior to filing bankruptcy. Worst case scenario, you file a Chapter 7. They're going to go back to American Express, get that money back, again, and distribute it evenly amongst all of your creditors. That really is kind of no harm, no foul, no skin off your nose, that kind of thing. It's the other type of preference that are involved with insiders. Now, insiders are family members, close friends, business associates. If you pay back money to an insider in the 1 year prior to filing of your bankruptcy, the bankruptcy trustee in your case can actually go to that family member, friend, whoever you paid back, and ask for that money back so that they can distribute it evenly amongst all of your creditors. So, for example, let's say that I am filing a Chapter 7 bankruptcy, and in the 1 year prior to filing bankruptcy, I have been making $500 a month payments to my brother for a loan that my brother gave me. If I made $500 a month for a full year prior to filing, that would be $6,000 of payments. If I were to file bankruptcy, the bankruptcy trustee can then go to my brother and demand that $6,000 back and then make an even distribution to all creditors. You can see how this can make Thanksgiving and other holidays really super awkward if you have a preference action where a bankruptcy trustee is going to a family member or a friend that you are repaying on a loan, and then they're getting that money back. So a couple ways to deal with it. One is you could just wait a full year from the time that the preferential payment is made. We also look to see the amount. If it's something where you paid back this family member $200 total, it's likely not going to be an issue. If it's like the example I shared where it's $6,000 in Arizona, 100%, that bankruptcy trustee is going to go and try to get those funds. Another option is you could still move forward with the bankruptcy, but then make some type of settlement arrangements with the bankruptcy trustee where you agree to repay those funds to the bankruptcy court rather than them going back to your family. So there are some options there, but if there have been significant repayments of loans, particularly to insiders, again, family members, friends, business associates, if those kind of payments have been made in the last 12 months, you may not want to consider a Chapter 7 bankruptcy. Now, the fifth area where you may not want to consider a Chapter 7 bankruptcy is if you are behind in your secured debt payments. Now, secured debts are any debt where there is collateral or property attached to the debt. For example, your home loan. If you have a mortgage, there's a deed of trust that connects the mortgage to your home, essentially creating a lien on your home. That's a secured debt. The debt is secured by that property. Also, car loans. That's another area. Boats, ATVs, RVs, those types of loans typically are secured and they're attached. The loan is attached to the property or the collateral. The result of that is if you don't pay your house payment, they're going to foreclose on your house. If you don't pay your car payment, they're going to repossess the vehicle. If you don't pay on the boat, they're going to repossess the boat, that kind of thing. If you're behind on those types of payments, Chapter 7 bankruptcy, while it will initially stop a foreclosure, it'll also stop a repossession. It doesn't do a whole lot as far as helping you get caught up, other than providing you about a 4-month window that you're going to need to get caught up. Otherwise, they are going to move forward with trying to take that property back from you. If you're in that situation, particularly if you're dealing with a home loan situation where you're behind several months on your mortgage payment, you may want to consider a Chapter 13 bankruptcy, which not only will stop the foreclosure and the repossessions, just like a Chapter 7, but it gives you anywhere from 3 to 5 years to get caught up on those missed payments. So if you're behind on secured debt payments and facing repossession, facing foreclosure, Chapter 7 is probably not the best solution unless your intent is just to let those assets go. You may want to consider a different option like a Chapter 13 bankruptcy. So hopefully that's helpful. If you're considering the bankruptcy process, there are times where Chapter 7 doesn't make that big as far as makes sense. And you may want to consider something more like non-bankruptcy alternatives or a Chapter 13 bankruptcy. If you're in the state of Arizona and you're considering bankruptcy, I do free consultations. You'll talk with me directly. Feel free to, my contact information is below. Set that up and we can let you know whether Chapter 7 is right for your situation. Thanks for watching.